بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا وقرة عيننا محمد وعلى آله وأصحابه وأتباعه إلى يوم الدين. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا بفيض فضلك رشدنا يا رب العالمين. Alhamdulillah, by the blessings of Allah subhanahu wa ta'ala, we are able to continue in our journey of looking at this great meta primer in Hanafi fiqh, Multaqa al-Abhur, and we're continuing in our section on judgeship, and we reached the ibara that ويجوز تقلده من السلطان الجائر ومن أهل البغي. So يجوز تقلده أي يجوز تقلد القضاء. So one can accept qada from the corrupt sultan, because one problem does not permit another, right? That the ruler is unjust, but justice needs to be upheld. And the qaida is ما لا يدرك كله لا يترك كله. What cannot be fully attained is not fully left either. What cannot be fully attained is not fully left. So that's the Sultan al-Jair. Al-Jair ay al-Zalim. Then he tells us, rahimahullah ta'ala, وَمِنْ أَهْلِ الْبَغِي, and from rebels. What are أهل البغي? أهل البغي, those who took arms against the government, right? And they've gained, and in this case, they've gained control over a certain region. So they're not the rightful rulers. You know, the government is fighting them. But in that region, they've taken control. Now, do we need to establish the laws, redress disputes, all the maqasid of qada? Do they need to be fulfilled in a land governed by the bughat? Yes. So if someone is a qadi, they are faqih, trained for qada, they can accept that role. Of course, morally, they hate the baghi. Morally, they hate the baghi, but they have to establish justice. There is one condition, which is إلا إذا كان لا يمكنه من القضاء بحق. كان لا يمكنه أي السلطان الجائر أو أهل البغي, unless they do not allow him to judge truthfully. Unless they don't allow him to judge truthfully. Truthfully, right? بالحق أي بالعدل, right? You know, حق, in fulfilling rights in the right way, right? So لا يمكنه or يمكنه, they don't allow him to judge rightfully. تماما. So one can accept from both a wrongful ruler, Sultan al-Jair, and from Ahl al-Baghi, except with this proviso that has been given. Tamaman. Then we have the next section, which is Adab al-Qadi, the conduct of the judge. So he tells us, rahimahullah ta'ala, that وَإِذَا تَقَلَّدَ, if they accept the judgeship, يَسْأَلُ دِيوَانَ قَاضٍ قَبْلَهُ, they ask for the diwan, the register of the qadi before them, so that they can use it. وَهُوَ الْخَرَائِطُ الَّتِي فِيهَا السِّجِلَّاتِ, and that is the registers in which there's a record of previous judgments. وَالْمَحَاضِرِ وَغَيْرُهَا, and the records and other related documents of the proceedings. وَيَبْعَثُ أَمِينَيْن يَقْبِضَانِهَا بِحَضْرَةِ الْمَعْزُولِ أو أَمِينِهِ. So he sends two upright individuals, trustworthy, who take possession of these documents from the ma'zul, from the judge, whom they are replacing, or their amin, or the person they were trust. Now, of course, the amin is the one they trusted. They don't have to be amin themselves, right? Because it could be that the qadi before was removed. Why? Because they were corrupt. And the guys working with him were corrupt as well. Would that handover be valid? Yes. So the Amin here, what does it refer to? The one, يعني بحضرة المعزول أو أمينه, or the one trusted by the Qadi that was removed, even if that person wasn't trustworthy. وَيَسْأَلَانِهِ شَيْئًا فَشَيْئًا, and they ask him for clarifications step by step, right? Why? So that there's a full handover, right? So that there is a full handover, right? So that there is a full and proper handover. So يسألانه شيئا فشيئا ويجعلان كل نوع في خريطة على حدة, and they place every type of judgment in its own خريطة, in its own record. Why? So basically, they accept a handover of the documentation, but if the documentation wasn't complete, there's a handover, but they ensure that things are properly categorized. They could have been turmoil with the previous judge. So, they ensure in the handover that the handover is complete and that procedure is followed in a proper way. This is one of the amazing aspects of the ulama built out a very strong procedural basis for qada in Islam, much of which has been disturbed in the colonial era by blind following of of European ways that disrupted a lot of the nizam al-qada in Islam. Okay. وَيَنْظُرُ فِي حَالِ الْمَحْبُوسِينَ, and they look at the state of those detained. فَمَنْ أَقَرَّ بِحَقٍّ أَوْ قَامَتْ عَلَيْهِ بِهِ بَيِّنَةٌ أَلْزَمَهُ أي الحبس وَلَا يَعْمَلْ بِقَوْلِ الْمَعْزُولِ. So whoever admits to a right, i.e. that they did not fulfill, or there is proof against him that would entail them being detained, right? أو قامت عليه به أي بالحق بينة, right? So they check, okay, these people who are imprisoned, do we have record of them admitting to it? Or do we have record of a proof against them? Then we keep them there. لا يعمل بقول المعزول أي بمجرد قول المعزول. We don't just take that, okay, these are the people in prison. Why? Because they're there. Because, right, when an amana, and there's a lesson in this, right? Qada has important lessons. When an amana is handed over, you don't just assume the amana as is. What is your responsibility? Is to ensure that the amana itself is being fulfilled. And that's an important lesson of Qada. Qada has many practical lessons for the believer, right? That sometimes we accept an amana. We have a responsibility. Well, this is the way things are. No. What is your responsibility with respect to the amana? Not merely the way things are, but rather the way the trust should be fulfilled. واضح? So this is an important aspect of that, right? وَإِلَّا يُنَادِي عَلَيْهِ. So if someone is imprisoned, but it's not clear why they're there, they call out to see, if there's a case against them. And if no case appears against the person, they just happen to be detained, يُخَلِّي سَبِيلَهُ. They let them go. بعد ما استظهر في أمره. After they clarified the person's affair. Because what is the basis of the human being? That they're free or that they're imprisoned?
Free.
Yes, that they're free. So they're being detained, what is it? It's an exception. Right? It's an exception. Is it a harm for someone to be detained? Naturally, right? It's a harm. So we only accept that harm. Why? To ward off a greater harm. They're not fulfilling someone's right. They've committed a crime. There's a punishment due upon them, etc. Otherwise, the basis is of the insan is hurriya. So that we have to ascertain and we have to periodically review that the people imprisoned are rightfully imprisoned. And we have to be aware of interest groups, right? Historically, there was interest groups. Why? Because there would always be people who are interested in people being in prison. Who would be interested in people being in prison?
The ruler.
No, the ruler, it costs them, right? But who really would want people to be in prison? Right? There is a whole industry always, right? There's nothing new under the sun. That if Uncle Latif provides the food and the services for the king's prison system, Uncle Latif, would they want more prisoners or less? So there's a new Qadi who comes in and they're letting prisoners go. Is going to affect people, right? And we have to, as ulama, we have to be aware, the ulama have to be aware of the way things are. You have to be aware of the way things are, that there are people whose interests go against what is right. And they will argue their case, right? Sometimes in colorful ways. No, we need to have, we need to have A, we need to have B. Why? Because their interests align with maximizing the people in prison and keeping them there, right? But the judge cannot be swayed by these interests, right? And this is a big driver in many countries for people remaining in prison, like the United States in the most egregious example, but other places, and this has always been historical case. And we need to be aware of these things. Okay. Otherwise, after clarifying, istadhara fi amri, they make their affair clear, they're let go. تماما. Then, ويعمل في الودائع وغلات الوقوف بالبينة أو بإقرار ذي اليد لا بقول المعزول إلا إذا أقر ذو اليد بالتسلم منه. So likewise, in items given in safekeeping, such as what? For example, there is an inheritor who was out of the country, and there's some inheritance. There's nobody to take it in safekeeping, so it's given to the treasury, right? So the qadi may have responsibility to oversee these things that are in safekeeping. Those are wada'i'. واضح? Right? وغلات الوقوف, and the earnings from the waqf. The qadi has to appoint someone to oversee the awqaf. Now there may be, so there's غلات الوقوف, right? The earnings of the waqf. So something's given as a waqf property. So let's say that the person who was administering the waqf had to be removed for mishandling the funds or misappropriating the funds, or they died. So now, if it's under the auspices of the qadi, and there's different types of qadi, but this qadi, there's some waqf earnings that are coming in. So how are they assigned, etc.? We don't just go by what's happening, right? But rather, we review these things bil bayyina, on the basis of proof, such as documentation, that this waqf, what is it assigned for, and where do its earnings go, or by the admission in whose hand it is in, right? In the absence of proof. So that the earnings from this waqf, which is under the oversight of the qadi, its earnings are supposed to go to fund those 3 madrasas. Okay, so the dhil yad is the one who has responsibility for the waqf. So the documentation has been lost, right? The qadi's registers were attacked by brigands and they stole all these things. So we don't have bayyina. We don't have documentation. We don't have proofs. So we go by Dhil Yad, the one who is administrating the waqf right now. لا بقول المعزول. We don't just take the word of the qadi who was removed unless what? Unless the Dhul Yad, the one in whose hand it is, admits to this, that this was the scenario. So all these confirmations are needed. And then in court, there is a procedure. And what is the procedure meant to do? The procedure is meant to ensure fairness. It's meant to ensure fairness, right? So that both parties, whether rich or poor, influential or not, both parties are given equal attention and no one is given extra favor. Number one. Number two, the qadi is, who's the qadi acting on behalf of? Who's the qadi acting on behalf of?
The ruler.
And who's the ruler acting on behalf of? Yes, the ruler is acting on behalf of Allah subhanahu wa ta'ala, right? So it's very important, right? This is one of the areas that is to be respected. Of course, respected with worldly limits, right? That it's not an unconditional respect, but it is an area that requires, right? It's ta'zeem. And it is something where there has to be uprightness and there cannot be shubha. That, well, the qadi sits next to the ruler in the cases where the ruler or the representatives of the ruler, the ministers, the viziers, judgment is being made against them. So then it would appear that the judge is taking sides with one of the two parties. And remind me, I will share some of the resources on some of the mafakhir min tarikh al-qada. So many times it's happened that rulers, viziers, influential people, judgment was made against them, not just from the early generations, but even from later generations. So this dignity is maintained how? وَيَجْلِسُ لِلْحُكْمِ جُلُوسًا ظَاهِرًا. They sit for judgment in a manifest manner. A manifest manner, meaning that in a way that is accessible to all people. Right? Fil masjid. Right? And the optimal place is the most public place in the Muslim community, which is the masjid. Fil masjid. Wal jami'u awla. And the central mosques, the ones Friday prayers established in, is even more befitting. Right? So that everyone would know where to go and how to get there. But they said if one established a Bayt يعني ولو جلس في داره وأذن في الدخول فلا بأس به. If the qadi sits in his home and gives permission to enter there, there's no harm in that. And في داره is يعني في دار, what does the dhamir go back to? The most obvious thing is in the qadi's own home, right? And this would happen if you think about small towns, right? Like you have a village, there's a large village, there's a qadi. So people go to the qadi's house, the masjid doesn't have enough space, right? If this is approved, لا بأس به. There's nothing wrong with it, but this indicates, what does لا بأس indicate, Sadati? What does the term لا بأس indicate? No, there's no problem with it, but what's understood from that? that there's nothing wrong with it would indicate that it's superior not to do this, right? That it's لا بأس به indicates that خلافه أولى, that it's better. They should be in because what's أولى is that it be in a public place, the masjid, particularly the jami', or they should be a dar al-qada. And the history of Islam, as you can see in the commentaries, right, that if they set up a dar al-qada is better. And it should be a public building, everyone knows where it is, it should be independent of government, the ruler, etc. And the same things apply, as the commentaries say, for the sultan, because the sultan should make himself accessible. The sultan and the representatives of the sultan should make himself available to hear the petitions of the common man, right? And they should not only take delegations from special interests, right? So that whether the poor or the rich, the one with influence or the one without influence, there should be julusun zahir, that if you have time, you allocate. Of course, there may be, you may need to accept to listen to people representing groups of people, but it's very important that, so the same principle that applies to the qadi would apply to the ruler, right? That they sit julus zahir, so they're accessible to all people and not to favor some over the others. Diyanatan, that's their duty. Same thing for the mufti. The mufti needs to make themselves available so that people can come to them for their questions. Wal faqih, and likewise the faqih, because the mufti gives fatwa, the faqih addresses people's questions and they teach people. That it has to be known, where can we go and learn, where we can go to, for our religious verdicts. Because the difference between the mufti gives fatwa on a new issue, but the faqih also applies the fiqh. So, you go to the mufti if there's a new thing that happens. But if Ibrahim is starting a company and she wants guidance on how do I set up the contracts, etc., does that need a mufti? No, that needs a faqih, someone who can apply the fiqh. So the faqih, they know the fiqh and they know how to apply it. The default in most of the classic, which is the mufti, al-mufti yahkumu fi nawazil. The mufti is the one who gives judgments over new issues that come up. But it's, these are matters of usage. Right? So this you can find in the commentaries, but it's an important point here. Right? Tamaman. Then he tells us, rahimahullah ta'ala, about accepting gifts. Simple, don't. وَلَا يَقْبَلُ هَدِيَّةً. And the judge does not accept gifts. إِلَّا مِنْ قَرِيبِهِ أَوْ مَنْ جَرَتْ عَلَيْهِ عَادَتُهُ بِمُهَادَاتِهِ. So the mufti does not accept gifts. Right? And hadiyatan, it's in the indefinite. Right? You notice that? It's the indefinite. What is the indefinite indicating here? This tankir is للتقليل. لا يقبل هدية, does not accept any gift. Right? Why? For that ta'zeem, so there be no shubha of this being a favor, a bribe, etc., or even indirectly. Because as the Prophet ﷺ said, جُبِلَتِ النُّفُوسَ عَلَى حُبِّ مَنْ أَحْسَنَ إِلَيْهَا. People are naturally disposed to liking those who do good to them. So the qadi loves fiqh. So you gifted him a book of fiqh. You gifted him a new book of tafsir. You invited him for dinner. And then you got into a dispute. Even unconsciously, they could be swayed. Except from their close relatives and those they had a habit of having exchange of gifts, a close friend, etc. But they said that this is only to the extent of the previous habit, right? Only to the extent of the previous habit. وَالِاسْتِغْنَاءُ أَوْلَى, and it's better even from relatives and close friends, not to you only accept to the extent that you used to get before, but it's better for while a qadi not to accept gifts and not to allow your family to accept gifts. And the ulama would apply this themselves with their students, so they didn't favor wealthy students over others, for example. And also to keep their teaching purely for the sake of Allah. What I've seen from many of my teachers, Shaykh Adib Kallas, Shaykh Hassan al-Hindi, Shaykh Muhammad Jum'ah, all of them, that they would not accept gifts. You're trying to be generous, whatever. Of course, forget accepting payment, but they will not accept a gift. One, so that the teaching is for the sake of Allah. They don't want to favor someone over someone else. Okay, so there's an ikhlas element and a fairness element that is very sensitive. But rather you find a lot of the ulama, they're lordly scholars are givers rather than takers. رضي الله تعالى عنهم وجعلنا على سلكهم. يا رب. Right? تماما. إن لم يكن لهما خصومة. And even then, even with the aforementioned, if there's no active dispute that they are one party to. وَلَمْ يَزِدْ عَلَى الْعَادَةِ, and they don't accept even from those more than what was the previous clear habit. Right? Because al-'ada is not just a habit. Al-'ada is al-mu'tad ala wajhin zahir. Right? The 'ada is that which is a clearly established habit. It's a clearly established habit. That's the 'ada. It's not, well, it's normal for me to accept gifts from him. When's the last time he gave you a gift? 10 years ago. Is that a habit? No. When's the last time so-and-so invited you for dinner? I was just recently talking to a good friend of mine. He's traveling and he wanted some fiqh question. And we're good friends. But I've been busy, he's been busy. We haven't had dinner together for several years. Right? So now suddenly he's having dinner with the qadi. Right? This is where وَلَمْ يَزِدْ عَلَى الْعَادَةِ. One has to be, exceedingly careful about that. And the same things would apply to a politician, for example, right? A politician, like even if you're a member of parliament, etc., that you have times where you accept petitioners to help your constituents, but to accept, so-and-so is inviting you for dinner, you go to this. Whose house are you likely to go to? Consciously or unconsciously? The poor, the needy, and the distressed? Is the single mother who's not able to pay her bills going to invite you over for a meal? And are you likely to accept the struggling student's invitation? Naturally, who's likely to say that to you? Who's likely to invite you for meals, etc.?
The wealthy.
Yeah, the wealthy, the influential, or those with interests in inviting you. Right? We hope, right? Our hope and good opinion does not allow us to be simpletons. Right? Rather, we act with caution while maintaining good opinion of people. Al-mu'min kayyisun fatin, as has come in the prophetic tradition. Al-mu'min kayyis, the believer is smart and aware. Fatin, they're aware of how things work. And Shaykh Abdul Rahman al-Shaghuli said, وَلَيْسَ كِيسَ قُطْنٍ, because kayyis, fatin, right? They're smart and well aware. They're not kisa qutnin. They're not like a bag of cotton that you can just do whatever you want with it. فنسأل الله أن يلهمنا الصواب تماما. Then he says rahimahullah ta'ala that the same principle applies to invitations. ويحضر الدعوة العامة لا الخاصة. One accepts public invitations, not private invitations. وهي ما لا يتخذ إن لم يحضر. And the general invitation, this private invitation, is one that would not be upheld if he wasn't there. Okay. ويشهد الجنازة ويعود المريض. And one attends the janazah and visits the sick, but in the same way as others would visit the sick. Right? In the same way as others would visit the sick. And if you visit the sick, you would visit not only the influential sick, but other people who are sick. Right? And one does not even visit the sick or the funerals related to those with whom, who has a case in court right now. So, Uncle Jamil has a case in court against Sister Zubaydah. Uncle Jamil's wife passes away. The Qadi should not go to the janazah because you don't want to appear to be favoring. You may send a note of condolence, whatever, but you do not visit the janazah so that you maintain maintaining his integrity is the shari'i priority. This tells us of the ethical standards believers uphold in other things as well. تماما. Court assistants. ويتخذ مترجما وكاتبا عدلا. They appoint a translator, right, and a scribe who are upright. So one has to choose these carefully, right? These are the translator, the mutarjim, and the katib. They have to be upright, and they say they have to have the right qualifications, and that's an amana. So you find some of the points related to this, right? So because they're translating, what are they translating? Legal procedure and legal details. They need to have knowledge of fiqh, right? They need to have knowledge of fiqh, and they have to be upright. And they sit in a place where the Qadi can access them and other parties cannot influence them. Right? So, this is with respect to court assistance. And he says, ويسوي بين الخصمين جلوسا وإقبالا ونظرا. And one is fair and does not give any partiality between the two disputing parties, the khasmain, in where they sit and the attention you give to them and you're looking at them. Right? So, and this needs careful caution, particularly with the wealthy, the influential, or the charismatic. ولا يسر أحدهما ولا يشير إليه. And one does not try to make one party happy nor point to them. Right? And one does not speak privately to one party. You saw in it also can be referring to surur or and لا يكلم سرا. Right? One doesn't speak privately to them or right? So yusar can be from israr, yes, yusar, or yasar, that they make them happy, right? So someone comes, they're sad, right? Someone lost her husband and she's making a case against the other inheritors. He doesn't let me speak to her privately, cheer her up. No, right? Someone, that the Qadi or others cannot do that. There has to be a stepping back, right? Because تماما. So that's واضح. ولا يضيفه ولا يضيفه دون الآخر. Right? One doesn't do ضيافة. One doesn't, serve, tea or coffee or any food for one and not the other. Same reasons. ولا يضحك إليه ولا يمزح معه. And that one doesn't joke with them nor jest with them. ولا يلقنه حجته. And one does not give them their proof. Right? Because sometimes someone is making a very poor case for themselves. They say, you ask them questions to lead them on. You're not allowed to do that. And this gets tricky, and the details of that, right? That sometimes one may pause the thing that said, we'll come back tomorrow, right? Why? Because at the same time, this is very sensitive, right? Because someone could be making a very poor case for themselves. So لا يلقنه حجته, but the judge has to also try to make sure that people make their case soundly, but they don't do that themselves. And the example of that from the Prophet ﷺ, right, is when the man came and admitted to zina. What did the Prophet ﷺ say? Alayhi salatu wassalam. He said, لَعَلَّكَ قَبَّلْتَ أَوْ مَسِسْتَ. Maybe you kissed or touched. So here the issue is that you're not telling them the proof, but if someone is acting in their manifest disinterest, the qadi might not accept their way. But then you don't give them their argument. So that's sensitive, and there are discussions on that. You should just be aware. ويكره تلقينه الشاهد بقوله أتشهد بكذا. And likewise, it's disliked to instruct them what they're bearing witness to, by, for example, by saying, do you bear witness to such and such? Right? Why? Because they may have no clue. But they say, oh, you're asking me if my brother was at my house? Say, yeah, he was at my house. But he only said that because they were asked. Right? So it's kind of pulling them along. واستحسنه أبو يوسف في غير موضع التهمة. But Abu Yusuf said this is fine in other than areas where this is suspect. Right? موضع التهمة. And the fatwa is on his position. So the qadi does not incite someone to give witness, but oftentimes people are clueless. What exactly am I here for, etc., etc., etc. So we facilitate for them, right? But not in a way that's leading them on, basically. And in a lot of the things, in Qada, the position of Abu Yusuf is taken. Why? Why is the position of Abu Yusuf taken in a lot of the issues of Qada?
He had more experience.
Because his practical experience, right? He served as a judge as well, right? He served as a judge, but it's not taken unconditionally, right? It was reviewed, right? And it's not really a difference usually of strength of evidence, right? It's in itself, the judge shouldn't tell the person what to do. Why? Because of the underlying reason that the witness should bear witness of something they're sure of. What if they that they're sure about it, but they're just clueless? So you're kind of standing there, says yes, say yes. Do you have something to say? Said about what? So just take, you have to be practical, right? You have to be practical. And that's part of, but we set up the procedure in a way that there isn't tuhma. Right? واضح إن شاء الله? Right? تماما. And then ولا يبيع ولا يشتري في مجلسه. The Qadi does not buy and sell in their majlis. Right? Majlis al-Qada. And the relied upon position is that the default is that the Qadi should not engage in trade during their Qada. Like when they are a Qadi. Why? So that there not be a tuhma. Okay? So that there not be a tuhma. Right? Right? So not in the majlis of Qada, because the Qadi is sitting there, and in big cases, families attend, etc. Say, I have books for sale that I've written. I have this and that. And people will want to buy from the Qadi. Why? To curry his favor. Right? So the Qadi should not buy and sell. And can they buy and sell? This would go back to procedural considerations, right? In different ages, different times. This, but it should not be on the basis of their fame as a Qadi. And especially in anything that could sway their judgment with respect to individuals. All this goes back to what in modern terms is often called conflict of interest, right? The Qadi avoids all potential conflict of interest. Right? And that's what tuhma is, right? Tuhma is an actual or potential conflict of interest. تماما. Right? So this لا يبيع ولا يشتري في مجلسه سادتي, this applies also outside the majlis in this consideration. Then he says rahmatullahi ta'ala alayhi, ولا يمازح, and they don't joke. And this is mentioned in some copies and some not. Right? لا يمازح, those who include this, they don't joke, meaning in general. The previous one was referring to between the two parties, right? You don't joke with one party or the other, right? But just in general, in the majlis of Qada, you don't joke with even the people there. Why? Because it could be perceived. The person you are joking with happened to be the family of one party, etc. You could make you appear to be giving preference to one party over another. These principles also apply, of course, in other situations. If you're a mediator between two individuals. In our community, if someone is a mediator, they are an adjudicator between two parties. It's called tahkim. Mediation, adjudication is informed by the same considerations. And that would also apply if two kids are disputing, right? Like sometimes it just, okay, we just deal with it as. No, but if there's a serious dispute between two children, so now the parent is mediating or adjudicating who's right and who's wrong, who owes what. What principles would we apply? These principles, right? We have to be very careful. Parents very easily fall into injustice. Now, of course, ultimately, we are responsible to do the best we can. But we have to be careful. We have to be careful. تماما سادتي. Then he tells us, rahimahullah ta'ala, that فَإِنْ عَرَضَ لَهُ أي للقاضي هم أو نعاس أو غضب أو جوع أو عطش أو حاجة كف عن القضاء. So if the qadi is overcome by some worry, right? Worry, he got a message that, your daughter has not come home and nobody knows where she is. So he's distracted. He's checking his cell phone, etc. He pauses. I need a recess. I need a break, and then he'll be back. Okay. أو نعاس, or drowsiness, or anger. Right? One of the parties, instead of calling him Your Holiness, called Your Lowliness. He got upset. Yeah, he needs to pause until, because justice requires اعتدال الطبع والحال. Judging fairly requires balance of temperament and state. That's one of the important things with knowledge and with uprightness and knowledge of fiqh and uprightness of conduct and character, but also balance of judgment. There's some people who have very poor judgment. There's some people who have good judgment, right? That is very important. Likewise, if they're hungry or thirsty or they have a need. Now, the need can often refer to what? Like they need to use the toilet because it's not conducive to paying full attention, or some other need. They're late for renewing their paperwork, or this or that. Any need, but often haja refers to al-haja al-bashariyya. But other things, that to do an errand for their elderly parents, they stop the qada. If these things are going to be a discussion, a distraction. If these things are going to be a distraction. تماما. And then وإذا تقدم إليه الخصمان فإن شاء قال لهما ما لكما وإن شاء سكت. And if two disputing parties come to him, he can ask about the case to get things going, or he can remain silent. And procedurally, as the commentaries explained, there's also something that the assistant, it's better for the assistant to do. Right? So the qadi maintains their detached objectivity. Right? They should be a procedural thing. That what happens pre-qada, that before the qada, how are things handled? That's, these things that, okay, you're going to the qadi, this, and other parties keep things flowing. So the judge himself does not appear to be influencing proceedings, right? Those things are best done by the people around the qadi. واضح سادتي؟ تماما. Then we move on to وإذا تكلم أحدهما أسكت الآخر. If one party speaks, he ensures that the other party is silent. تمام. Then habs, imprisonment. So here he says رحمه الله تعالى وإذا ثبت الحق للمدعي وطلب حبس خصمه, if the right is established for the claimant, the mudda'i, and he seeks the detention of their adversary, فإن ثبت بالإقرار لا يحبسه, right? If the right is established by the person's admission, they're not detained. إلا إذا أمره بالأداء فأبى, unless the one who owes the money is ordered. Say, yes, I owe the right. So, okay, then pay up. He refuses. Then you're detained until you pay up. وإن ثبت بالبينة حبسه قبل الأمر بالدفع. But if the case against him is established by proof, right? If the claim is established by proof, he did not admit to it, right? So Zubair owes Uncle Jamil a certain amount of money. He does not admit to it. Right? He does not admit to it. Yet, what happens? Proof is established against him. So there's, of course, things before. Like, no one would raise the case unless there's been a refusal for payment. Right? So in ثبت بالبينة, he's detained even before he is asked to pay. وَقِيلَ لَا. And it is said that not. And the first is more correct because the very fact that he didn't pay up is indicative of refusal. Here, there's a small point that this exception here in the matn, right, which says إِلَّا إِذَا أَمَرَهُ بِالْأَدَاءِ. Can you guys see it? إِلَّا إِذَا أَمَرَهُ بِالْأَدَاءِ فَأَبَى. This is the stronger of the two opinions, contrary to what is in the Durar and also the Kanz. Of course, the tartib would be except for contrary to what is in the Kanz and the Durar. Right? They did not make this exception. And it's useful, like if you like Sidi Abdul Latif, if you studied the Kanz or are going to study it, it's good to cross-reference things like this. Right? When ulama point it out to cross-reference, it's very beneficial. Even if you have the Durar, it's a good exercise for Talib al-Ilm. Even if you're not ready to, to do the whole thing, right? It's just to just to open the section, try to find it, and put it there. If you can't, just, you take a snapshot of the thing, right? Print it out, for example, or just write it on a paper and stick it in the section on habs. So when you get to there, then you can figure out that there's something, or you put a post-it note in the section on habs in the Kanz and a post-it note in the Durar, noting this point, right? Because knowing what different books are saying, even if you're not ready for it right now, you've not studied the Kanz, but when you come to it, you don't want to miss out on a point like this. Tamaman. Then he says, rahimahullah ta'ala, فَإِنِ ادَّعَى الْفَقْرِ. So if the case is established against the person, but they claim poverty, حَبَسَهُ فِي كُلِّ مَا لَزِمَهُ بَدَلَ مَالٍ كَالثَّمَنِ وَالْقَرْضِ. So if the case is established against someone, but no, you owe this money to so-and-so. If he says, I don't have money, they are detained in everything that was due in exchange for mal. Such as what? Like the price of an item. You purchased something and you haven't paid. Or a qard, you borrowed money, but now you say, I don't have money. Why? Why would this be? Right? So they have a beautiful expression. Imam al-Haskafi, how does he express it? Imam al-Haskafi says, لأن التزامه باختياره دليل يساره. It's a beautiful expression. لأن التزامه باختياره, because your willful taking on of this debt indicates your capacity. Why would someone buy something? Because you have the money to buy it. Why would you take a debt? Because you have the ability to pay it. Right? So that's the reasoning, and there's a legal principle that's important to note down, which is من سعى في نقض ما تم من جهته من سعى في نقض ما تم من جهته فسعيه مردود عليه. Anyone who takes the steps to negate something completed from their side, that effort, that striving is rejected. Right? And that's a general principle. من سعى, whoever strives, في نقض, with a ضاد, نقض, في نقض ما تم من جهته, to negate something that was completed from their action. فسعيه مردود عليه. That effort is, you bought the thing, they said, Judge, I don't have any money. That's not rejected, because then why did you buy it? The assumption is that you're a rational actor. You're a rational being. Al-insan hayawanun aqil. You're of course, sadly, Allah subhanahu wa ta'ala tells them, بَلْ أَكْثَرُهُمْ لَا يَعْقِلُونَ. But we have to at least work on the assumption of intelligence. نسأل الله العافية. واضح? Right? So in these, they would still be detained until it's proven that they can't. Right? أو بالتزامه, right? So either it was due because of money from their part, or بالتزامه, or something they took on, كالمهر المعجل والكفالة. Right? They themselves took it on. Zubayr married Zubaydah for a mahr of $1,000 due up front and 9,000 payable in 9 months' time. The nahr al-mu'ajjal, you took it on. So if you don't give it, she takes him to court, right? Second day, she takes him to court. Zubaydah takes Zubayr to court, and he says, Judge, I don't have the money. She doesn't accept it. She proves, look, I have the contract. It was due immediately without delay. So Zubaydah can have her husband detained. And he can, the judge could give him, okay, you have a few days to pay up. Otherwise, he'll spend his honeymoon in jail. أو الكفالة. Likewise, you chose to be a guarantor, then saying I don't have the money is not accepted. لا فيما عدا ذلك, but not in other things. Why? Because why? Because the ulama had this discussion that what is the basis of the human being? Financial ability or financial inability? Right? What would be the basis of the human being? Financial ability or inability? Yes. So know that by what Allah subhanahu wa ta'ala tells us, خُلِقَ الْإِنسَانُ ضَعِيفًا. The human being has been created weak, being created needy. Right? The dunya is, we know that there's ibtila bil mal. Human beings are tested with wealth, right? And this practical experience, right? You look at most societies, a large percentage of the society is not financially secure. That's part of the ibtila of dunya. خلقنا الإنسان في كبد. لقد خلقنا الإنسان في كبد. We've created man to toil and struggle. Yeah, was it? إنك كادح إلى ربك كدحا فملاقيه. You are struggling in your striving to your Lord, and you will meet him. Right? So anyways, so it is accepted. Right? That if he says, I don't have the money, in other than this situation, it would be accepted. Where you willfully entered into a contract or took on a commitment. In others, he is not detained if he said, I'm poor. إلا إذا برهن خصمه أن له مال. Unless his adversary, Zubaydah, in some other case, proves that the other party, her husband, has money. Right? Acceptable proof, of course. ويحبسه مدة يغلب على ظنه أنه لو كان له مال لأظهره هو صحيح. And he's only detained for a period of time that the Qadi would be sure that if the one whom the case is established against has money, they would manifest it. Why? Because sometimes someone doesn't want to pay, then deal with it. I'm not going to pay, deal with it. Eventually the other party gives up. No, we want to preserve rights. Right? So he's detained till the person said, let me out. I have money. I can figure it out. Let me out. Right? Because people do not want to be detained. So detention is a deterrent. وَقِيلَ شَهْرَيْنَ أَوْ ثَلَاثَ. And others said 2 or 3 months. And this is قِيلَ Because ultimately it's left to the judgment of the Qadi unless procedure is established, right? Unless procedure is established. More senior Qadis could, to simplify Qada, could say, if someone is owed money, they stay for this long. If someone owes this, they stay for this long. Just to facilitate Qada, because using judgment for every case complicates Qada. But those kinds of judgments are reviewed. Yeah, so this is where the qila comes in. فَإِن لَمْ يَظْهَرْ لَهُ مَالٍ خَلَّ سَبِيلَهُ. But if no wealth appears for this this person, he lets him go. إِلَّا إِذَا بَرْهَنَ خَصْمُهُ عَلَى يَسَارِهِ. Unless the adversary can prove that he has financial capacity. فَيُؤَبَّدْ حَبْسُهُ. In that case, the detention is kept continual. A case would be, for example, someone owes a debt. Zubayr owes Zubaydah. Zubaydah is Zubayr's third wife. 2 previous wives have passed away. So Zubayr committed to this mahar, and he also purchased things from Zubaydah to start his business. Zubayr has money because he has 6 kids from the other marriages, but he's made a commitment. I want to pay for the college for each of my children. So he has $120,000 but he's demarcated for his children, but they still remain in his bank account. What comes first? Paying a debt or the money you've set aside for your children's university? Yeah, the debt comes first, right? So this would be a case. No, but you have to understand, I cannot use that money. That's for my children. What should he have done? He should have given it to the children if he wanted to set it aside. As long as it's yours, debts come before commitments and promises. Of course, if he already owes the money, he cannot then give that money to his children. Rather say, no, you guys have to give it back because these debts have to be cleared first. Right? So that would be a case of someone refusing to فَيُؤَبَّدْ حَبْسُهُ. So they're detained indefinitely until they pay up. And very often it's related to children, etc. He says, وَلَا يُسْمَعُ الْبَيِّنَ عَلَى إِعْسَارِهِ قَبْلَ حَبْسِهِ. And no proof is accepted for his being poor before detention. Someone says, I have proof that I don't have money. Now, firstly, right, and this is what most of the scholars, so he says, عليه عامة المشايخ. This is what most of the scholars are upon, right? Because what is a bayyinah there to do? What is a bayyinah there to do? Like, al-bayyinatu lil-ithbat. I know. In general, a bayyinah, a proof, is to affirm something. It's not to negate. Al-bayyinah ala al-mudda'i, the one making a claim, and you're affirming something, you give proof. Right? The one negating swears by Allah subhanahu wa ta'ala. But the affirmative proof, the proof is affirmative, not negative, by default. Right? And also, proving a negation is very difficult. I want to prove that I don't have any money. What? Right? So he brings 2 witnesses that I don't have any money. What's the problem with that? What's the problem with that normally? That those 2 people may not know that he has money elsewhere, right? Right? So look, I'm bringing my 2 closest friends, they can prove I don't have money. No, they can't. because they may not know that you have money elsewhere, right? So this is the relied upon position. Some of them said that, right, that unless there's evident proof to confirm his poverty, then that would be a different thing, right? Right. So, and you can find that in the commentaries, right? Al-mu'awwalu alayhi ra'yuhu. That the basis is that by default you don't listen to the a proof that he's poor before he's detained. But in some cases, right? So like someone, everybody knows in society, this guy is a servant. He has no money whatsoever. And everyone who knows him, right? Because al-bayyin la yaftaqir ila bayan, the clear thing. So this safeguards the right of the poor. The guy is poor. He said, look, I don't have any money. And so there it's left to the judge that if it's manifest, but this would most likely be accepted from the poor, right? And the disadvantage that they have no money. Why detain someone who, and in detention, there's nothing to admit. Right? So you make a note of that this is by default, unless in evident cases where it's manifest that the person would not have money, then this would be accepted. Tamaman. And then وَيُحْبَسُ الرَّجُلْ لِنَفَقَةِ زَوْجَتِهِ. A man may be detained for the nafaqa of his wife. Right? لا والد في دين ولده. But a father is not detained for a debt owed by the son. إلا إذا أبى من الإنفاق عليه. Unless the father refuses to support his child. So there's a couple of things, right? That a man may be detained for the support payments of his wife. This would apply to, because some support payments are due month by month, right? So Zubayr was traveling, and in July he didn't provide for his wife. She needs to demand it in July. She can't come in September and say he owes me a month, right? Because that support, because otherwise, it's impractical and unenforceable, right? But this will, the nafaqa of the zawja that is legally mandated, which would be for the mu'tadda, right? For the one in idda, or if it's a situation of non-providing where the qadi stipulates an amount that is due every month. And that would be of course, we're going to leave aside support payments post-divorce because shar'an, they're not due. After the idda, the woman is not owed support payments. And I mean, that comes up in Bab al-Nafaqa, and that's tricky in our times, but it's a reality, right? But if, Zubayr is negligent and he refuses to support his wife, the qadi may stipulate that Zubayr, you have to give this much per month. That qadi supported, the judge determined amount. If he refuses to pay it, then he may be detained, right? So the father is not detained for the debt that his son owes, but he may be detained if he refuses to spend on his children, right? Waladihi means his children, right? Tamaman. Then we have وَلَوْ مَرِضَ فِي الْحَبْسِ. If the detained person becomes sick in detention, لَا يَخْرُجْ إِنْ كَانَ لَهُ مَنْ يَخْدِمُهُ فِيهِ. Then he cannot leave it in a detention if there's someone who can come, i.e. into prison, and take care of him, serve him, i.e. take care of him in prison. وَإِلَّا أُخْرِجَ. Otherwise, they're allowed to go out to be treated. But they would take a kafil, a guarantor that they return. Okay? And then these are other cases ولا يمكن المحترف من اشتغاله فيه هو الصحيح. And a professional is not given the facilitation to work in prison. That's the valid opinion. So a carpenter can say, okay, I want to bring my carpentry equipment in there, because what's the purpose of the detention? What's the purpose of the detention?
To pay what's owed.
Not only to pay what's owed, but to rectify, right? That get with it, commit to repayment, right? So if he can just work, right? So someone, so let's say Bilal, is a bit of a slacker. He takes on a few debts, he gets imprisoned. So it's okay, he can set up his carpentry in jail, right? In detention. So he's fed in detention, this and that, he's working. You don't have to pay rent. If you're a single guy in Canada, in Toronto, you have to pay, in Canadian, let's say $2,400 for an apartment. You can just be in detention instead. It would just cause a lot of problems. And then people would remain there. But you want to create enough iz'aj, sufficient discomfort that the person wants to get out of there. So they'll pay up, or they'll commit to pay up, etc., and rectify, as Ibrahim mentioned, right? So they're not allowed to work in there, right? And ويمكن من وطئ جاريته إن كان فيه خلوة, right? But they are allowed to have visitation, right, with their wife or their jariya if there is accommodation for that, right? So, right? So the wife would not be detained with him, right? But so like what's called spousal visitation is something that the Sharia recognized that they would be given the opportunity to fulfill their sexual rights in detention in this way, right? And the proper thing would be that imprisonment would be done in a way that, in a dignified way, away from others, that there be sexual visitation rights. And go ahead. Was there a question, Sayyidi? تماما. Then he says, وَإِذَا تَمَّتِ الْمُدَّةِ وَلَمْ يَظْهَرْ لَهُ مَالٍ خَلَّى سَبِيلَهُ. But if the duration of the detention is complete and no wealth appears, so he's not hiding money, he's allowed to, he's let go. وَلَا يَحُولُ بَيْنَهُ وَبَيْنَ غُرَمَائِهِ. But what does not separate between him and those owed debt. بَلْ يُلَازِمُونَهُ. Rather, they would have the right to follow him, right? So they would have the right to follow him in public, right? Or at his work, not in private, right? So they can't come and sit in the living room, right? But they would have the right to follow him in order to claim their rights, right? ولا يمنعونه من التصرف والسفر. But they cannot prevent him from dealing with his own property or from traveling, except with permission from the judge, right? Because let's say he's from Turkey, he wants to go visit Turkey, he could disappear there, which would be a mafsada, right? Which would be a mafsada. So they don't prevent him from dealing, tasarruf in his debt or suffer. He's a free man from transacting or travel. وَيَأْخُذُونَ فَضْلَ كَسْبِهِ. But they have the right to demand the extra of his earning. وَيُقَسَّمُ بَيْنَهُمْ بِالْحِصَص. And it was divided between them by the share of their debt. وَالْمُلَازَمَةَ أَنْ يَدُورُوا مَعَهُ. And mulazama is for them to remain with him. حيث دار, wherever he goes. فإن دخل داره جلسوا على الباب. And if he enters his house, they can remain. Of course, the debtor wouldn't normally be someone else. Remain at the door so that he feels the pressure, the social pressure of paying up. تماما. ولو كان الدين لرجل على امرأة لا يلازمها. Right? If the money is owed by a woman to a man, he doesn't follow her, right? Because that is a aib, right? But rather, what would he do? Right? بل يبعث امرأة تلازمها. But rather, he would send a woman to watch over, to do this on his behalf. وقال إذا فلسه الحاكم يحول بينه وبين غرمائه إلى أن يبرهنوا أن له مال. Right? The Sahibain said that if the judge declares the person bankrupt, muflis, that it's proven that he has no money whatsoever, then the judge can say, now you have no right to follow the man. Right? Till they can prove that he has money. Right? Why? Because this is a harm. The guy, it's proven he has no money. He's totally bankrupt. So he has the harm of being bankrupt with the harm of this mulazama. Right? Right? So ad-darar la yudfa' bid-darar. Harm is not lifted by harm. Right? We only accept the harm, and this is mulazama. It's the social harm, right? Anyone passing by Zubair's house sees that these guys sitting waiting to collect their debt. So it's a harm, but it's done so that he pays up. When it's proven that he has no money, then he's let go. Tamaman. So then that was what we wanted to cover today about a lot of the important, in this double lesson about the importance of judgeship, to understand who can be a judge or a mufti, and to go over the proper conduct of the judge when he assumes his role, and to understand how the judge deals with the debtor. And there's many lessons related to how we take care of fulfilling huquq and iltizamat. Next lesson, we're going to look at issues of judgeship and arbitration. Okay, this is a subsection in the work, so we'll strive to go through that fully next time. Any questions before we close, Sadati? تماما. So we'll pause there for today. وصلى الله وسلم وبارك على سيدنا ونبينا وحبيبنا محمد وعلى آله وصحبه وسلم وآخر دعوانا أن الحمد لله رب العالمين والسلام عليكم ورحمة الله تعالى وبركاته.